Let's talk about California gun laws and also red flag laws and also what's really happening with this. First of all, you have two forces really vying with each other for the gun control narrative right now. Now, on one side, the timing what the Supreme Court has done couldn't have been more significant. The Democrats, of course, found their big issue. You had the shooting in Texas. You had Democrats roll out across the whole United States pushing for tighter gun control laws. Not only Democrats, but around the entire world, the left has been trying to crack down on guns. In places where they've already cracked down on guns, they're going after knives, like the UK and Australia. Now, as this has happened, however, as they're trying to roll forward on this train, creating really, really strict gun laws in the United States, including the passage of red flag laws, Biden has now signed those into action. So those are now law, including red flag laws that could allow the government to actually seize your firearms, right? The Supreme Court, Clarence Thomas being one of the main ones who pushed this, has made a ruling that it's going to make it very, very difficult for any of these laws to continue. And keep in mind, too, the Supreme Court has previously, even back, I believe, last year and back in 2015, made rulings that could overturn any red flag laws anyways. Not as just a violation of the Second Amendment, but also a violation of the Fourth Amendment. I'll be explaining this. First, let's talk about what California is doing, though. This is kind of the momentum for more strict gun laws. And this is really what I think a lot of people who are conservative have been concerned would happen. California is really enacting the concern that people have. Now, it says here, this is according to Reason. They say, State Attorney General suggests considering applicants' ideological viewpoints in denying carry licenses. So your viewpoints, your thought crimes, your opinions, these things could be used to determine whether or not you are eligible to own a gun, or at least to have a concealed carry permit on that. Now, it says further in, the AG's, Attorney General's office, suggests that people who hold certain ideological viewpoints should be disqualified. And this is an actual quote from the document, from the opinion. It says, existing public carry policies of local law enforcement agencies across the state provide helpful examples of how to apply the good moral character requirement. Now, it says the Sacramento County Sheriff's Office, for example, currently identifies several potential reasons why a public carry license may be denied or revoked, which include, quote, any arrest in the last 5 years, regardless of the disposition, or any conviction in the last 7 years. It is reasonable to consider such factors in evaluating an applicant's proof of the requisite moral character to safely carry firearms in public. See E.G. Bruin, referencing law-abiding citizens. Other jurisdictions list the personal characteristics one reasonably expects of candidates for a public carry license who do not pose a danger to themselves or others. Now, how do you define what poses a danger to yourself or others? Well, that's loose interpretation, right? The Riverside County Sheriff's Department policy, for example, it's in California, currently provides as follows, quote, legal judgments of good moral character can include considerations of honesty, trustworthiness, diligence, reliability, respect for the law, integrity, candor, discretion, observance of fiduciary duty, respect for the rights of others, absence of hatred and racism. And remember now, racism is being defined so broadly it can even include like support for like American history or capitalism. That they actually have absence of hatred and racism in there. Just the problem is, of course, not that racism or hatred might be an issue, but that the broad interpretations of what that mean are pretty dang broad these days. Fiscal stability, profession-specific criteria such as pledging to honor the Constitution and uphold the law, and the absence of criminal conviction. Now it says, as to how law enforcement is to figure out such matters, the AG's office, the Attorney General's office, has some advice, and this is what they're saying. This is how they want to make sure that you have good moral character, quote unquote, as defined under all the stipulations I just mentioned. They say, among other things, quote, As a starting point for purposes of investigating an applicant's moral character, many issuing authorities require personal references and/or reference letters. That's the normal one right now. But they're saying investigators may personally interview applicants and use the opportunity to gain further insight into the applicant's character. And they may search publicly available information, including social media accounts, in assessing the applicant's character. Now, the problem with this is you're going to have essentially a government official assessing your character based on their assessment, looking at your social media account and so on. And if they see anything that would suggest that maybe you're against the Constitution, or you're not fiduciary, you're not financially responsible, or maybe they say you're a racist, or maybe you have hatred, maybe you're unhappy about something, right? Well, you can't have a gun. And that's how the law is being interpreted. Let me show you the actual legal document. This is from the Attorney General's office, so you can see it. This is the original document right here. Folks, now what this means essentially is that they're instituting thought crime, really. Thought crime not in the sense they'll throw you in prison for this, but thought crime in the sense that you will be denied basic constitutional rights if you don't meet the government's character criteria. Now, a lot of people would argue, well, you have to screen some people. But, the problem with this is really the interpretation of what some of these terms mean, frankly, and how broadly that could be interpreted. Because what this could constitute is really what social justice is. Social justice meaning a political moral standard. It's morality, right? Good moral character. Morality as interpreted by the government. The government is trying to interpret what constitutes morality. And if good moral character is being essentially measured, and your freedom is being measured on good moral character as the government defines it, this means that you have to abide by the government's standards of what defines morality, which may actually conflict with your religion or your belief. Now, if we go back to 1967 China under Mao Zedong, which is where the term social justice comes from, that was, of course, a moral system defined by the Chinese Communist Party. Political correctness, is where political correctness comes from. It is the moral system as defined by the government. If you are following the dictates of the government at the time in China, that meant, killing your landlord or beating your teacher to death if you were a student, or, beating up rightists or Confucians or killing people who believed in religion, that was considered politically correct. That was what the government wanted, and that was what was considered moral under the dictates of the government. If you went against that, you were deemed politically incorrect. You were going against the morals of the government, and you could also be persecuted for that. The other thing this is starting to sound a whole lot like is the social credit system, where in China, the government again has its own standards of morality. The government defines what is right and what is wrong, and if you abide by it, you have more freedom, and if you refuse to abide by it, you have less freedom. Your social score, your credit score, right? Credit score like your financial credit score, your bank credit score, only in this case being interpreted on how closely you follow what the government wants on a moral level. That is what this constitutes, the government defining morality. Now, we'll see how this goes. They're trying to basically interpret existing law is the problem with this. And so they don't necessarily have to create new laws to enact this. They're going by current standards. And the problem with these current standards is, again, a lot is left up to the individual government officials' interpretation and opinion based on their analysis of you or others on whether you should be able to have your constitutional right of having a firearm. Now, on that note, very likely this will not stand. And this is where it gets really interesting. The Supreme Court ruling just recently on the New York concealed carry permit laws, this is likely going to overturn many gun control laws across the entire United States, at the very least, and makes them very susceptible to lawsuits, because the burden for a lot of this is no longer on you. The burden now is on the government. And it was missed by most media. I think most people didn't even know this was in the ruling from the Supreme Court. This is the most significant part of that ruling. Let me show you this. This is Vox, funny enough. Vox is, of course, complaining about it, but they say this. The Supreme Court's new gun ruling means virtually no gun regulation is safe. And they're right. It says this. The Supreme Court's 6-3 decision in New York State Rifle and Pistol Association versus Bruin is a devastating decision for anyone who cares about reducing gun violence, they claim. It massively expands the scope of the Second Amendment, abandons more than a decade of case law governing which gun laws are permitted by the Constitution. That's 10 years, i.e., well, frankly, Obama policies. And replaces this case law with a new legal framework that, as Justice Stephen Breyer writes in dissent, imposes a task on the lower courts that judges cannot easily accomplish. It's going to be very hard for judges to take away your guns at this point, in other words. Now, further in, it says this. Talking about one of these cases. The case in New York, right? It's a 109-year-old case that was just essentially overturned by the Supreme Court. And it was a law in New York which required anyone who wishes to carry a handgun in public, whether openly or concealed, to demonstrate proper cause before they can obtain a license to do so. An applicant must show a special need for self-protection distinguishable from that of the general community or of persons engaged in the same profession. Similar laws exist in other states: California, Hawaii, Maryland, Massachusetts, and New Jersey, plus the District of Columbia, Washington, D.C. Together, these jurisdictions make up a quarter of the U.S. population and a much higher percentage of the country's urban population. In effect, that has meant very few residents of those states have been able to legally carry a firearm in public, a handgun in public. Now, we can look at the violence in these states and know that, well, even those tight regulations didn't stop handguns from being carried, because typically you can still carry a handgun, you just can't do it legally. And if you're a criminal who has no problem doing things illegally, you have no problem carrying an illegal handgun, which has been the problem they faced over and over again, which is why you tend to have very high gun murder rates in, frankly, these exact same places. Justice Clarence Thomas strikes down the New York's that century-old gun control law. This is the important part. It says here, Clarence Thomas announces that the government, again, the Supreme Court Justice, the government bears the burden of showing that any gun law, this is where it gets interesting, the burden is now on the government. If the government wants to maintain a gun control law, the burden is now on them, and the government has to show that any gun law is, quote, consistent with the nation's historical tradition of firearm regulation. And Thomas declares that, quote, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. And to sustain gun regulation, moreover, quote, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. What does that mean? It means that just about every gun law in the country is now at risk of being overturned. Because under the Constitution, under the written historical tradition of firearm regulations of this country, codified in the Constitution of the Second Amendment, it is a right that shall not be infringed. Now, people are arguing, well, what about muskets and cannons and such? Well, give me a musket and a cannon. I wouldn't mind one. But frankly, I would say this, that if they believe the Constitution only allows you to carry a musket or a musket or maybe own a cannon, then that should apply really to police, because it's the federal government. That should apply to the bodyguards of government officials. That should apply even to the military. If they're suggesting, again, that this is a militia issue, right? A organized militia, right? You should maintain an organized militia. Technically, that would even affect the military. And so if they want to interpret the Constitution like that, the military shouldn't be allowed to carry anything other than muskets.